Thank you very much to Alexandra and Martin and Jakob and Greta and all of you for joining us here today. And thank you for inviting me to do this. I regret though that, I regret both that I'm not doing it with you and that we're not doing it this time last year when we expected to do it. But in any event, it's great that we can do it using this technology. What I want to do today is to give you a flavour of the Irish case law that relates to vulnerable persons in immigration and asylum matters. And if you do want to read further on any of the cases that I mention, they're all cited in the paper that I hope that you have, and you can access all the judgments in English on Ireland's court's website. What I'm going to say to you today isn't exhaustive. I hope it's though illustrative of the kinds of issues that have arisen in litigation before the courts here in Ireland in situations involving vulnerable persons. The first half of what I'm going to say will look at some of the cases that have arisen in the context of asylum. The second half will deal with immigration. As Ireland, though, has a unique relationship with EU law in these contexts, how that relationship applies to the two areas, and it applies very differently to each, I'll note at the start of each of the two sections. So, I can move. Well, I hope the PowerPoint is still working. If it doesn't, just let me know and I'll see what I can do. In any event, in respect of Ireland's relationship with EU asylum law, Protocol 21 of the TFEU gives Ireland a right to participate in Title V measures, if it so chooses. Of the first stage asylum measures, Ireland participates in the Asylum Procedures Directive, the Qualification Directive, and for what it's worth, the Temporary Protection Directive. Of the recast measures, Ireland has opted only into the Dublin III regulation and the Reception Conditions Directive recast. As Ireland is not participating in the other recast measures, the unusual situation arises whereby Ireland is required to give effect to key secondary EU asylum law that generally no longer applies in other member states, including the Czech Republic, while EU asylum law measures applicable in most other member states are not applicable in Ireland. Nonetheless, as the substantive legal requirements in the two sets of instruments are similar, much, if not all, of Ireland's EU asylum law will at least be potentially relevant insofar as national law is relevant to colleagues in any member state. Now, hopefully this is still working. Right, good. The first context in the area of asylum that I'll consider is the Dublin regulation. Of course, many issues concerning vulnerability can arise in this context. One significant issue that had been before the Irish courts for several years, creating a backlog of cases before the courts, was whether the first instance and appellate Irish decision-making authorities had jurisdiction to apply the sovereign discretion in Article 17.1 of the regulation. This is of importance to vulnerable persons because it's often the context of that discretion in which vulnerable persons ask the state to derogate from application of the hierarchy of criteria for determining which member state is responsible and instead to take responsibility for assessing the claim in Ireland. After much time in litigation, the Supreme Court clarified in a case called NVU and the Refugee Appeals Tribunal that only the minister had the power to apply the sovereign discretion. The system is now running more smoothly, and we can expect to see claims from vulnerable persons invoking the discretion being made to the minister and, in due course, case law on arising challenges. But for now, I'll just mention one case that provides an example of a creative solution for a vulnerable person in the Dublin process. On the facts of a case called Asylum and the Minister for Justice, a case from 2011, it was proposed to transfer a heavily pregnant woman by ferry to the UK for the purposes of the regulation. It was common consent too late in the pregnancy to transfer her by air. As Ireland was obliged to protect Ms. Aslam under Irish constitutional law and also to take steps to safeguard her unborn child, Ireland could not take any steps that would unnecessarily jeopardise or compromise the life or health of either Ms. Aslam or her unborn child. This meant to assure her dignity, her transfer by sea during winter conditions could not be considered at her late stage of pregnancy. The High Court granted an injunction restraining transfer to the UK by sea or by air, but did not restrain the minister from transferring Miss Aslam by road to Northern Ireland on the understanding that she would not be removed from the island of Ireland pending the delivery of her child. As a footnote, as the applicant's husband was a refugee lawfully resident in Ireland, the birth of the child in Northern Ireland would bestow entitlement to Irish citizenship on the child. A neat solution with a surprise benefit for the migrant family from a time before Brexit. Now, the second context to look at is, and I hope it's, the second context is, well, reception conditions. Now, it must be kept in mind that Ireland only opted into this directive in 2018. The decision to opt in was prompted by a court case in Ireland from the Supreme Court that clarified that a provision in Irish law barring asylum seekers from working was in breach of Irish constitutional law. In effect, opting into the directive allowed for a structured approach for asylum seekers to access the labour market. In any event, because Ireland has only been participating in the directive for a short time, there is little case law on it currently. Nonetheless, one case of note is X and Y and the Minister for Justice, a 2019 case. On the facts of this case, a single mother and daughter applied for asylum on the 17th of September 2018, but the Irish authorities did not provide them with accommodation until the 15th of October of that year. The court held that between the making of the application and the issuing of the decision on accommodation, the minister was in breach of the directive's requirement that member states shall ensure that material reception conditions are available to applicants when they make their application for international protection. The court also held that the applicant was entitled to Frankovich-style damages for the breach of EU law. The court awarded €1,500 jointly to the applicants by way of damages. In so doing, the court emphasised that what occurred as a result of the breach would have been particularly stressful for Miss X, who had the particular pressure that comes with being a single mother responsible for an infant child. This, to my knowledge, is the only occasion of an award of Frankovich damages to an asylum seeker in Ireland to date. Now, in respect of the qualification directive, there has been a significant number of Irish court cases involving vulnerable persons that are relevant to that directive. I'll just mention three categories. They'll be persons with SOGI claims, victims of trauma, and victims of sexual exploitation. Several cases, in fact, have come before the courts concerning LGBT-type claims. I will just share two examples. The first case provides an example, to some extent, of how the CJEU judgment in the A, B, and C case has been received by the courts. The court in WH and the Tribunal, a 2019 case, rejected the argument that the CJEU judgment in A, B, and C was authority for the proposition that it was an error for the tribunal to consider the appellant's inability to answer questions that were put to him about his knowledge of gay rights groups, organisations and personalities in a neighbouring country as part of the assessment of the credibility of his declared sexual orientation. The court considered that the questions put by the tribunal were not based on stereotypes, but arose because of a statement by the appellant that he engaged in campaigns and seminars to advocate for a particular gay rights activist in the country in question. The court observed that the LGBT self-identification aspect is a part of, rather than distinct from, the assessment of facts and circumstances. Thus, it seems that what will be appropriate as a line of questioning will depend to an extent on the facts of a case and the claim and the statements made by an applicant. For the second example, I have in fact two judgments about the same case, but separated by 3 years. Together, they seem to me to suggest a development in Irish case law demanding greater standards in the assessment of SOGI cases. In a case called DU Nigeria and the Tribunal from 2018, the applicant sought international protection on the basis that he would be targeted because he is bisexual. The tribunal rejected his appeal because it rejected the credibility of his claim. The applicant sought judicial review, but the court rejected this, saying that perhaps some isolated sentences are not necessarily phrased in the best possible way, but that cannot be equated with an entitlement to quash the decision. Those isolated comments were that the tribunal had said that it was not credible that a young man, having been raised in a restrictive environment, would engage in behaviour both unacceptable and outlawed in the society in which he lives. That it was not believed that a bisexual man would have naked selfies of himself and his partner on his mobile telephone, because if he was caught with such photos, that would lead to a lengthy prison sentence. And that there was consideration of whether Mr. X, in his first months in Ireland, had invoked the assistance of LGBTI plus rights organisations or visited any gay bars or clubs. The same applicant came before the court again to challenge his deportation order in X and the Minister for Justice, a 2001 case. At this point, the court was not concerned with the legality of the asylum decision. Nonetheless, it was extremely critical of that earlier decision and took the unusual step of identifying and criticising the comments made by the tribunal, which the court considered to be irrational. The court said that in dealing with the applicant's asylum case in the way that it did, the state was at risk of falling short of attaining that general moral ideal which it recognises and seeks to attain in its asylum regime. The next case, though it deals with a SOGI claim, is really about how vulnerable applicants need to deal with the effect of trauma on memory in the way in which they present their case. The applicant in LP and the tribunal, another 2021 case, claimed he would face persecution in Zimbabwe because he is gay. The tribunal found his claim to be gay lacking in credibility in light of inconsistencies in evidence at the core of his claim. The applicant furnished the tribunal with a medical legal report that stated he suffered from PTSD and depression. The report also stated that the applicant was in a psychologically vulnerable state and explained how current medical research showed that a common symptom in depression is reduced memory and capacity, and that depressed patients can have poor memory recall. However, the tribunal found that there was no finding in the medical legal report that the applicant had a problem with memory, and noted that the applicant did not report any problems with memory or cognition. The applicant nonetheless claimed that depression can have a negative impact on the capability of an affected person to remember, and that the tribunal did not consider this properly. The court rejected this and agreed with the tribunal because it found that there was no evidence before the tribunal that the applicant had difficulties with his memory. The court emphasised that the psychologist in the report had reported that the applicant did not report any problems with memory or cognition. Thus, the court found no link between the point made about the effect of traumatic events on memory and the applicant's actual case, leaving the inconsistencies unexplained. This case perhaps underlines how if a vulnerable applicant is not equipped to report a difficulty in respect of capacity during the asylum process, there is a risk. The last case I will look at in respect of the qualification directive relates to sexual exploitation and internal relocation. The applicant in NNM and the tribunal, a 2020 case, was a citizen of South Africa. She claimed she left South Africa to avoid a forced marriage. The tribunal accepted her credibility and found that state protection in South Africa was inadequate for her. However, it refused her claim because it found that internal protection was an option. The tribunal identified Cape Town as the location of the internal protection alternative. The tribunal found that the applicant would not be at real risk of suffering serious harm there. In respect of whether it was reasonable for her to settle in Cape Town, the tribunal noted that Cape Town had one of the lowest rates of unemployment in South Africa, which, in the view of the tribunal, indicated a likelihood of her securing gainful employment there, obviating fears that she might fall into prostitution or exploitation. However, the court found that the tribunal failed to consider two things. First, that there was a very high rate of unemployment in South Africa generally. The court said that having the lowest rate of unemployment is of little importance if the unemployment rate itself is itself very high. Secondly, there was no assessment by the tribunal of what supports would be in place for the applicant in Cape Town, especially in circumstances where the country information showed that there was a risk there of prostitution and exploitation. In light of the failure of the tribunal to carry out this analysis, the court quashed the tribunal's decision on internal relocation. Excuse me. So in respect of identifying an applicant, in respect of the Procedures Directive, identifying an applicant as vulnerable or in need of special procedural guarantees under the Procedures Directive, including if necessary at appellate level, in order to ensure an effective remedy, can of course entail significant changes or additional steps in the Irish international protection process. Such measures, at least at first instance, and certainly possibly at second too, can include not requiring a vulnerable applicant to give oral testimony, generous adjournments to allow for medical reports, allowing an appellant to request an interview or a tribunal member of a particular gender, or permitting a child to have an appropriate adult present for an interview or a hearing. I will, though, here just note two matters of importance arising from the Procedures Directive that have been the subject of recent Irish legal debate. And they are medical examinations and the widening of jurisdiction in relation to deeming applications to be inadmissible. The first aspect, medical type cases. The applicant in a case called MR Albania and the Minister, a 2020 case, challenged the Minister's failure to set up a medical panel for the purposes of the asylum process. The legislation provided that where a question arose during the asylum process regarding the physical or psychological health of an applicant, the decision maker could require the applicant to be examined and a report in relation to the applicant's health to be furnished by a registered medical practitioner. However, the Minister had not set up such a panel. The court noted that a misunderstanding of the scope of the provision was clear, in that the Minister thought it was only for medical examinations where applicants could not attend for interviews or appeals due to illness, whereas its scope, the court said, was wider. Indeed, for example, it seems that it could be used to assist in diagnosing medical concerns relating to capacity of an applicant, so that particular vulnerabilities could be catered to in the process. The applicant sought an order requiring the establishment of the panel. Granting the order, the court commented that the absence of the panel meant that a request for medical examination could not be considered in its correct context, and that a decision not to commission a medical report could not command confidence in that it could appear to be influenced by the absence of the panel. An emerging case of analysis relevant to vulnerability is that of applicants at risk of poverty. I've gone one PowerPoint slide ahead, and I've got so many screens open, it's difficult to get at this and move it back. There we go. An emerging case of analysis in any event is that of applicants at risk of poverty in other member states where they have international protection. The applicant in a case called HZ Iran and the Tribunal, a 2020 case, was an Iranian national who had refugee status in Greece. He left Greece, came to Ireland, and then reapplied for asylum here. His application was recommended to be deemed inadmissible because he had refugee status in Greece. He sought to review this decision in the High Court. On the facts of the case, the applicant had mental health issues and claimed he had no access to accommodation or healthcare. The court acknowledged that the decision of the CJEU in Ibrahim provides that in an inadmissibility decision, the member state's competent authority should have regard to Article 4 of the EU Charter, which prohibits torture or inhuman or degrading treatment, and in particular treatment of that kind in another member state, which must attain a particularly high level of severity in the limited number of cases where this might apply. The applicant contended that the tribunal was irrational in finding that he fell short of establishing that his fundamental rights would be infringed if he was returned to Greece. However, the court held that it was open to the tribunal to find as it did. The applicant's case fell short of the threshold at which mutual trust between member states breaks down, which is to say, the test of extreme material poverty. The applicant argued that the tribunal went wrong, also in failing to seek assurances from the Greek authorities about the conditions he would face if returned there. The court rejected this argument because the applicant would have had to demonstrate at first sight a case that Article 4 Charter rights would be breached for the need for such assurances to arise. So, well, in any event, that's my summary of some of the recent case law of particular relevance to vulnerability in the asylum context. And we'll move on now to immigration matters. And again, EU law is not a basis of immigration law in Ireland in the way that it is for other member states. This again is because by virtue of protocols to the TFEU, EU measures relating to immigration law generally do not apply in Ireland. In particular, by virtue of Protocol 21 to the TFEU, and unless it chooses otherwise, Ireland does not take part in legal measures adopted under Part 5 of Title 3 TFEU, with the exception of Article 75. And with one exception that is not relevant to us today, Ireland does not participate in those EU immigration law measures. In respect of victims of domestic violence, Ireland's immigration guidelines for victims of domestic violence provide arrangements for residency for foreign national victims of domestic violence where the foreign national's immigration status is derived from that of a perpetrator of domestic violence. The guidelines enable lawfully resident victims of domestic violence to get immigration status independent of the perpetrator of the violence. The permission granted to successful applicants puts them in the same migration status they had enjoyed as dependents of the perpetrator. In a case called Par Hiar and the Minister for Justice from 2014, the minister had argued that her discretion to grant residency was not constrained by the guidelines and that she was free to disregard them. The court disagreed, finding that the guidelines constituted an invitation to persons to whom they applied to engage with the minister in relation to their immigration status without fear of being disadvantaged. However, more recently in S and the Minister for Justice, a case from 2020, the Court of Appeal held that the minister's discretion was in fact not fettered in considering applications under the guidelines. Mr. S had made the application under the guidelines after a significant lapse of time after his abusive wife left the state. Even though the applicant provided information in line with what the guidelines suggested to support his claim, his application was lawfully refused because the minister did not believe the evidence showed that the applicant was a victim of domestic abuse in the sense intended by the guidelines, even if there had been abuse in the past. In respect of victims of human trafficking, Ireland participates in the EU Anti-Trafficking Directive, and Irish administrative immigration arrangements set out the criteria for the recovery and reflection period and the temporary residence aspect for trafficking victims. The arrangements provide that an individual identified as a suspected victim of human trafficking shall be granted permission to be in the state for 60 days for recovery and reflection. They also set out the criteria for granting a temporary resident permission valid for 6 months. However, the administrative measures were criticised by the Irish High Court in a case called P and the Chief Superintendent of the Garda National Immigration Bureau, a 2015 case. In that case, 2 years passed after the applicant sought a declaration that she was a suspected victim of human trafficking without a decision being made as to whether in fact she was. In that time, she had been sent for trial on charges related to the human trafficking matter. The police yet nonetheless had not made a decision, and their reason for not making a decision whether to identify her as a potential victim was because they doubted her account. The court said that the police's concentration on the truthfulness of her claim could lead, and did lead, to a decision maker overlooking that what is at stake is not a matter of entitlement to a status, but a measure facilitating the investigation of a crime. Thus, a person should be identified as a suspected victim if there are reasonable doubts, if there are reasonable grounds indicators that he or she is a victim, the test being an objective one. Thus, even an unconvincing account would be enough to trigger the identification if, as a matter of fact, there was objective evidence of trafficking. The court commented that better rules or even legislation was needed to establish what to do when a person claiming to be a victim of human trafficking is also suspected of criminal activity. A word on inferior medical treatment cases. As we know, in Papashvili in Belgium, the European Court of Human Rights elaborated on the correct approach to the negative obligation not to expose persons to a risk of ill treatment prescribed by Article 3. It indicated that other very exceptional cases beyond situations such as those in the seminal cases like D and N can raise potential breaches of Article 3 ECHR in medical treatment cases. Papashvili was considered by the Irish Supreme Court in a case called DE and the Minister for Justice, a 2018 case. The Minister for Justice in this case had issued a deportation order against DE, a child born in Ireland to Nigerian parents. An application was sought to revoke the order on the basis that, as a child with sickle cell disease, he should not be deported. The applicant's doctor provided a report. It stated that the applicant had quite severe sickle cell disease, noting that he had been admitted to hospital for life-saving blood transfusions on 2 occasions. The report said that while the blood transfusion procedure in Ireland is safe, this could not be said of the procedure in Nigeria, and that the child's requirement for blood transfusion suggested exceptional circumstances. The minister refused to revoke the deportation order, finding that the applicant's circumstances did not rise to the level of a risk of imminent death. Subsequent to the minister's decision, the European Court gave judgment in Papashvili. Understandably, the applicant had not presented the case using what the Irish court called the refined criteria of Papashvili. The court remitted the matter back to the minister so that the minister could let the applicant explain and try to persuade the minister that he in fact met the very exceptional criteria. The court acknowledged that Ireland would have to consider whether the care available in Nigeria was sufficient and appropriate in practice for the treatment of the applicant's illness to prevent him being exposed to treatment contrary to Article 3. It would then have to consider the extent to which the individual would actually have access to such care in the receiving state. If serious doubts persisted, the Irish authorities would have to get individual and sufficient assurances from Nigeria that appropriate treatment would be available and accessible. However, one of the justices of the court, in a separate concurring opinion, said that Papashvili should be viewed essentially only as procedural and clarificatory, and not as a guide or encouragement of further expansion of Article 3 in these types of cases. Finally, I'd like to summarize key cases about the deportation of parents of Irish children. If a minor Irish child's parent is deported, there is a risk that the child will be separated permanently from that parent. This is so particularly given the potentially lifelong effect of Irish deportation orders. 3 Irish Supreme Court cases are of particular importance on this: the AO&DL case, the Bode case, and the Ogwekwe case. In AO&DL and the Minister for Justice, a case from 2003, the Supreme Court held that a foreign national parent of an Irish minor child did not have an automatic entitlement to remain in the state with the child. Rather, the minister could deport the parents of an Irish child so long as the minister properly considered whether there were grave and substantial reasons associated with the common good that require that deportation. Deportation of the parent would typically involve the constructive deportation of the Irish child, even though the child, as an Irish citizen, had a right to reside in Ireland. And again, because the Irish deportation mechanism is both exclusionary and lifelong in its effect, this would mean lifelong effect unless revoked. The Irish state could justifiably interfere with an Irish child's residency rights where there is sufficient reason associated with the common good for a parent's deportation. In dissenting judgments, 2 members of the court took the view that the constructive deportation of an Irish child of 10 years automatically and unarguably deprive that child of the possibility of being nurtured and educated in the country of his or her citizenship. Following the judgment in the case, applicants applications for residency on the basis of parentage of an Irish child were no longer accepted. Instead, the minister would entertain representations about Irish children in deciding whether to make a deportation order against a parent. In Bodé and the Minister for Justice from 2008, migrant families with Irish children argue that the rights of Irish children had to be considered in a residency application rather than being considered only at the stage of deportation. The Supreme Court rejected this argument. In the court's judgment, the minister was required to consider rights of the applicants in the context of a proposal to deport or an application to revoke a deportation order, and there was no need to consider the Irish children's rights otherwise. The Supreme Court in Ogwekwe and the Minister for Justice, also from 2008, provided specific guidance for the minister when deciding whether to deport the parent of an Irish child. On the facts of the case, the minister gave no reasons for the deportation of the parent of the Irish child, save to say that refoulement was not an issue in the case. The Supreme Court considered this inadequate and provided a list of factors that the minister should consider when deciding whether to deport the parent of a minor Irish child. Many factors are set out in the judgment, but in summary, they require that if the minister's office is to take a decision to deport the parent of an Irish child of tender years, the decision must consider the facts relevant to the personal rights of the child protected by the Irish Constitution, identify a substantial reason which requires the deportation of the parent, and make a reasonable and proportionate decision. Subsequently, the CJEU gave its ruling in Zambrano, which we all know well. As a result of that ruling, many Irish parents of Irish children whose deportation was permissible as a matter of Irish law could then not be removed from the state in order to guarantee the EU citizenship rights of the Irish children. Nonetheless, in a case called Okanadi and the Minister for Justice, a 2012 case, the Irish Supreme Court confirmed that EU citizenship law developments notwithstanding, the Irish constitutional right of an Irish child to the company, care and parentage of his or her parents in Ireland is not absolute, and Irish citizenship does not determine a claim for residency for a parent of that child. Nonetheless, there has now been a renewed emphasis on the importance of Irish constitutional principles in ensuring that Irish citizen children may live in the state with non-national parents. And I realise I've gone a little over my time, but I hope not too much. And even though I suspect many of those points are very different to the kind of issues that perhaps are the bread and butter of what you need to do for vulnerable cases in the Czech Republic at the moment, I hope at least that gives you an interesting snapshot of some of the issues that have been of legal debate in Ireland recently. Thanks very much.